Hello and welcome to SCAN's TV program called Caregivers First. I'm your host, Lynette Whitman, and our show provides caregivers with information and resources for caregiving, including topics such as legal issues, health insurance, physical wellness, nutrition, and other helpful topics. Our guest today is Annemarie Schreiber, who is an attorney from Carluccio, Leone, Dimon, Doyle, and Sacks. So welcome, Annemarie. Thank you so much for joining me today.
Thank you so much for having me, Lynette.
It's great to see you. So tell me about the law firm that you work with. Where are they and what sort of law do they do?
Carluccio, Leone, Dimon, Doyle, and Sacks is located in downtown Toms River. We're really very centrally located. We are right near the library. We are right near the courthouse. The work that we do is we promote ourselves as a full-service law firm, which means that we cover all areas of the practice of law. We do elder law, which I do. There's family divorce. There's real estate. There's commercial. There's litigation, criminal litigation, personal injury litigation. So we really do just about everything.
Everything. Wonderful. So you are the elder care attorney, elder law attorney. So tell me about what that means. Like, do you have special training to be that? Do you take courses after law school? Explain to people what that really means to be an elder law attorney.
Well, there's a lot of people who practice in the area of elder law. Elder law is an area of the practice that focuses on the senior population as well as people with disabilities. I've taken it a little bit further than just practicing in the area of elder law. I've become a certified elder law attorney, which did require me to practice for at least 5 years in this particular area. I had to take a test just like the bar exam. It was a whole nother test, a whole nother day. It was very arduous. I had to also have various references. I had to have about 5 references from people who were familiar with my work and could recommend me. After that, I was accepted, and every 5 years I have to renew that process. So it's above and beyond what was required for me just to become a lawyer in the state of New Jersey.
So if somebody is actually looking to go to an elder law attorney, is there something, let's say they Google somebody or they find an attorney, how do they know? Is there initials after the name, or how would they know, oh, this person is the elder law attorney?
For the distinction of being a certified elder law attorney, you'll see after their name the acronym CELA, C-E-L-A, Certified Elder Law Attorney. And but there are other attorneys, when you do a Google search or any type of a search on your computer, that if people search elder law, wills, trusts, estates, anything like that, you could get somebody who does that type of work.
Okay. All right. So there's a specific initials that you should look for. And do you recommend people that are caregivers or spouses caring for people, or just people planning who are older, planning for their future, go to an elder law attorney? Is that something that you would recommend to people?
I do recommend that, Lynette. I do. And one of the reasons is a lot of attorneys can do a lot of different type of work. But the law has become more and more specialized. So really having somebody who can do it all is becoming less common. Mm-hmm. With elder law, there are certain nuances to every area of the law, elder law included, that to go to someone who really specializes in elder law or is a certified elder law attorney, it's really to your advantage.
I think for most caregivers, when they're thinking about elder law, and most people, it's so overwhelming to think about it, and so people sort of understand wills, what that is, but then you're talking about power of attorney and advance directives and guardianships. It gets very, very overwhelming for people to understand this. So basically, everybody knows they need to have well, everybody knows it, not everybody does it.
Yes.
But I think most people know that they need to have a will, or it's a good idea to have a will. So let's talk a little bit about powers of attorney. What is it? When should you get it? What is that world of power of attorney?
A power of attorney is a document that authorizes an individual to handle your financial matters on your behalf. That person becomes what they refer to as a fiduciary. That fiduciary is referenced as an attorney in fact in the power of attorney. He is your agent. That individual, and there's a whole list of different financial responsibilities that your power of attorney can take on your behalf. You can also limit what your power of attorney can do. For example, if you had a home down in Florida and you wanted to sell your house up here in New Jersey, but you didn't feel like coming up for the closing, you could hire a power of attorney and restrict it just for real estate. And you could handle it, that individual could handle your real estate transaction for you. And there's a couple of different types of powers of attorney. There's a durable power of attorney. A durable power of attorney will stay in effect even if you become incapacitated. There's a springing power of attorney. A springing power of attorney springs into effect. If you become incapacitated, it will spring into effect. The issue with a springing power of attorney is that it doesn't take effect until you're incapacitated. So there has to be proof that you became incapacitated, which requires that a doctor's note be accompanied with the springing power of attorney. My only caution about a springing power of attorney is that oftentimes when there's a crisis, when somebody's become sick, you need that power of attorney and you need to act with it quickly. If it is a springing power of attorney, it ends up that you need to first go and get to the doctor, have the doctor confirm that the individual is incapacitated, so you're losing time. Some people will say to me, well, I don't feel comfortable with giving so much authority to another individual, all my finances. I first recommend whoever you name as your power of attorney, whether it's in a springing or a durable, trust that person. If you have any reservations, you shouldn't be naming that person in the document. So make sure you trust the person. I'll tell you, I can't tell you how often I've had people who have come to me to prepare a document, such as the power of attorney, and I'll ask them, you know, who they'd like to choose. And let's say they're picking from their children. And they'll tell me that I'm picking Janie because she's my oldest, not because she's the most qualified for the position. I say to my clients, now's not the time to worry about hurting the kids' feelings, picking Janie because she's the oldest. Pick the one that you are confident is going to do a good job.
And so when you select Jamie, let's say, you fill out a paper and you get a piece of paper saying Jamie's my power of attorney. And then you have to send that paper to Jamie to keep on file so that, God forbid, something happens to you, she could produce that piece of paper saying I am, right?
I don't always recommend that they keep it, send it to their agent. I will tell them, here's your document, put it in a safe place. Let your agent know where it is. Okay. Again, most times it's the kids and the kids have access to the house. I put it in my safe deposit box at the bank. I put it in my safe in the house. I put it in my file cabinet. Let them know where it is. Oftentimes when somebody executes a power of attorney, they'll take it to the bank so the bank is aware of it. So that is helpful as well, that the bank it's already on file. So if somebody has to sign a check, they already...
But definitely tell that person.
Yes, absolutely.
You're my power of attorney.
Absolutely.
But without that piece of paper, nobody's going to listen to them, right?
You are absolutely right on that.
Yeah, you just can't call up a hospital and say I'm the power of attorney.
Anybody who is serving as a caregiver, if they are also going to take on the added responsibility of handling the financial matters for that individual, it is recommended that the caregiver have a power of attorney or know who the power of attorney is.
So the other thing that's confusing to me and other people, I think, is a living will versus an advance directive. So you go to a hospital, and I think, you know, you're giving the insurance card, and they always say, oh, do you have a living will? I don't know if they ask if you have an advance directive or not. What is the difference between a living will and an advance directive?
Oftentimes people nowadays use those terms interchangeably.
Okay.
Technically an advanced medical directive, and they call them advanced medical directive, healthcare proxy, health directive, living wills, again. A lot of people just, same document, multiple names. An advanced medical directive or a medical directive, healthcare proxy, you name someone, similar to like how you name somebody in your power of attorney. You name somebody to serve as your agent to make medical decisions. That agent is going to step into your shoes and make medical decisions for you. If the doctor turns to you and feels that he can't obtain informed consent, he's going to want to know who is your agent, who has the responsibility, the authority to make decisions on your behalf. A living will is slightly different. Living will, you set forth what your wishes are. If you were to become ill, do you want a feeding tube? What kind of treatment do you want? Do you want CPR done? Nowadays, when people prepare an advanced medical directive living will, those two documents have been combined. Oftentimes when you see that, and again, going to an elder law attorney, you're more guaranteed that you're going to have that combined document. It names an agent for you to make decisions, but it also has what your wishes are, which then helps guide your agent under your advanced medical directive as to what your wishes are. Because a lot of times some decisions are made almost on a moral or ethical type basis. So I say to everybody, when you pick your agent for your advanced medical directive, talk to them. Make sure they know what your wishes, your desires, how you feel about things. Because it's very, very important. That person is going to stand in your shoes. Mm-hmm. And if there's a tough call to make, a medical call that's very, very tough, you want someone to feel comfortable in making that decision.
So the power of attorney is financial, and the medical directive person is medical.
Yes.
So, and it's not necessarily the same person.
No, it does not have to be the same person. No.
And again, this is something that should be discussed if there's children involved with the children, and because honestly, I think whoever has the medical decision making, the medical directive power, that's a tough role, and especially if there's children and there's mom would have wanted this and you can't do that. That's a hard thing. You have to really discuss that in the family.
I have to tell you, I don't know. I do think it's a very, very tough decision, and sometimes I think some of the family members think, that, oh, mom didn't name me in a document, or dad didn't name. Sometimes you're better off not being the one named, quite candidly.
Oh, it's awful.
But I had a sad case that a woman came to see me, and she was the agent for her husband under his advanced medical directive. And whatever health condition he had, he knew that there was a possibility of a certain type of procedure, and he had instructed her that he never wanted to undergo that procedure. When he was sick and in the hospital, the doctor had asked if they should do that procedure, and the wife consented to it. The same procedure he had said he never wanted. And sadly, her husband couldn't communicate after the operation, but had enough wherewithal to make faces at her. Yeah. And she said he died shortly after that, and it was horrible. Yeah. But I had said, you know what, your job was to stand in his shoes, not to make the decision you wanted to make. Mm-hmm. Mm-hmm.
Hold that thought. We're going to just go to a quick commercial break, and we will be right back with Annemarie Schreiber.
You probably already know that rehabilitation is a must for successful recovery from surgery, injury, or serious illness. What you may not know is that you're free to choose where you go for rehab. In Monmouth and Ocean County, the compelling choice is Care One. Where you choose to go for rehab matters, and with Care One, you have 4 convenient locations to choose from in Monmouth and Ocean counties. Care One at Jackson, Care One at Wall, Care One at Homedale, and Care One at King James in the Atlantic Highlands. At Care One, you'll work with a team of experts to develop a plan based on your needs and goals. You'll have the full support of caring, compassionate physicians, RNs, licensed therapists, and nutritionists dedicated to helping you recover successfully without setbacks, at a pace that makes you comfortable and successful in meeting your rehabilitation goals. Once you take the first step with us, you'll never look back. Call 877-99-CARE-1 today and come for a tour.
Welcome back to Caregivers First. I'm your host, Lynette Whitman, and I am so thrilled to be joined today by Annemarie Schreiber, who is an elder law attorney. So, Annemarie, you're giving wonderful information to people. Thank you so much. One of the things that I hear a lot, because I deal with people who are caregivers and caring for somebody with Alzheimer's disease. So, what advice do you have for people? My thought is that people should go as soon as the diagnosis is given, but what advice do you give to caregivers when they're facing this awful journey ahead of them?
I do think that the sooner somebody gets to an attorney to have the proper documents in place, the better. Oftentimes, if I have somebody who comes to me and they have advanced stages of cognizant defect, I may not be able to help them. I may not be able to prepare the documents for them, because the person who signs the document has to have the ability to do so. Ability mentally, they have to understand what they're signing, what they're committing to. And if they can't understand that, there's an ethical issue with me having them execute that document. So it is important. You can't wait until the last minute when it's a crisis, because a crisis turns into a whole nother problem with a lot more implications, and it's just better that you get things done at an earlier stage rather than later.
So one of the things is that people are being diagnosed earlier now. It used to be much more of an illness of denial and non-diagnosis, but it's great advice for people if they are diagnosed with that, just to put that on the list, put that on their checklist of what to do.
I absolutely agree.
Yeah. And I think a lot of people, again, now think that they could do it themselves, that they could go on the internet, and I imagine you could fill out all these forms: power of attorney, advance directive, living will, whatever. What do you say to people that want to do it themselves online? What is the upside or the downside to that?
Well, the upside would be that it's usually cheaper. Mm-hmm. The downside is that those forms that you find online are very generic forms. They are not tailored to fit New Jersey at all. So New Jersey has some nuances to its laws, things that are allowed or may not be allowed, that generic document does not address. So I do think it's important for people to go to an attorney and have the proper documents prepared.
And do you keep the records, the files, or you just give them to the person? Do elder law attorneys, do they have a file of all the papers, or is that not allowed? I was always confused by that.
When somebody comes in to have their paperwork prepared, I give them their originals and I give them a copy. I do scan their documents, and we have them in our computer, a scanned copy. Some attorneys do not keep the fully executed documents. My office does.
Okay. And okay, so somebody comes to you and they have 2 grandchildren that they wrote in their will, and then they have a 3rd grandchild. Now, I know a lot of people that just write in on their will, oh, now give it to Debbie, baby Debbie, and initial it. Is that legal, or that's not?
No, it's not. In fact, I always tell everybody when they prepare their wills with me, and I say to them, here's the original, here's a copy. If you have any changes, do not write on the original. You can invalidate it. It may become invalid, and if your will is invalid, then it's like you had no will at all. And the state of New Jersey will then dictate where and how your money goes through the intestacy laws. Huh. So I always say, don't do it. It's not the proper way to do it. If you have changes, even if it's a minor change, you don't have to have a whole new will drawn up. You could do a codicil, which is like an amendment to the will, but don't write on it directly. Okay. Do not.
Okay, because that could just negate everything.
Yes.
And do you recommend, or do you like when somebody's making out a will, that their whole family comes in with it, and that the kids come in, so it could be discussed? Or do you think it's better just to have the parents do it and then send it to the kids, not send it to the kids?
I will tell you, when somebody calls and they ask if they could bring their son, their daughter, whatever, I don't mind the son, the daughter, the family member sitting in on our general discussions, because I think it can be informative. That similar to what we're talking about today, is what I bring my clients through. And I talk about what a power of attorney, advanced medical, the will, how they all interplay with each other, what's the duties and responsibilities. So that general conversation, I think it's beneficial. I think it's beneficial for everybody to hear. But when it comes time to talk about the nitty-gritty, I talk one-on-one with my client. I do not have the whole family. Especially, it is not uncommon that parents have several children and only one's accompanied. So there's always a question, is that child unduly influencing the parent? Are they manipulating the parent? Something. And it's better if I'm one-on-one, I can get a feel for. I've had people who've brought their parents in and said, he needs a power of attorney. And he's holding it together during that general conversation. He seems good. As soon as the kids walk out the door and I'm talking one-on-one to dad, I'm not a doctor. I'm not there to diagnose whether somebody has a dementia or a memory loss. But if I am not comfortable with my conversation with the individual, I will say to the family, you know what? I need a letter from a doctor saying he can execute these documents. Mm-hmm. It's not worth the aggravation that could come down the line if I had him executed and there was a challenge to it. So if I have any questions about somebody's ability to sign a document, I ask for further clarification.
I want to talk about guardianships, but before I do, I just have to ask you. So for the advance directive or the living will, are you allowed to write on it, or that will negate, like let's say, oh, I wanted a feeding tube. No, you know what, I don't want a feeding tube. Can I write on that?
I still wouldn't write on it. It's not as strict as with the will, but if you wrote on it, the original document is witnessed, it's notarized, there's a lot of detail to it. If you just write something in, the doctor may question who wrote that in.
So it's
the doctor may question. That's why it's better to have a comprehensive typed document. Okay.
You mentioned a little bit ago about if you're not sure about somebody's competency, you might need to get a doctor to verify that that person is. Talk to me, that's another whole issue of guardianships. When is that necessary? When does somebody have to do that? Is there a way to not have to go through that? What is that world of guardianships?
I'll start by answering how to avoid the guardianship. Okay. And it's not a 100% foolproof method, but if you have your power of attorney, somebody to handle your financial matters, and you have your advanced medical directive, somebody to handle your medical decisions, that's really what your guardian is going to do. So if you have those two documents in place, you're better prepared and less likely to need a guardian. That does not mean if you have those documents in place and your family begins to fight about you, that somebody might pursue a guardianship. Okay. But a guardianship is an individual is at risk. They're at danger for either they're unable to make medical decisions, they're unable to make financial decisions. And because they are at risk and because they no longer have the capacity to sign a power of attorney, the capacity to sign an advanced medical directive, a guardianship is necessary. A guardianship is a costly endeavor. It's a court intervention, so you're before the court. When you do your own power of attorney, your own advanced medical directive, you're picking who you want to be your agent. If you need a guardianship, the court is involved. The court may end up deciding who's going to make those decisions, who's going to handle your finances, who's going to handle your medical decisions. So a guardianship, it's costly. You are required to be evaluated by 2 doctors who give the opinion that you are no longer able to make your own decisions. Those documents, the doctor's reports, are submitted to the court. A court-appointed attorney is appointed for the individual who's alleged to be incapacitated to protect their interests during the legal proceedings. That individual, the court-appointed attorney, needs to report back to the court. The court has a hearing to determine who should be the guardian. If the family is all on board because there had been a crisis, that nobody ever thought about having a power of attorney and advanced medical directive, and all of a sudden mom got very sick and she needs to go into a nursing home and nobody has the authority to sign the paperwork, or the doctor's looking for direction, a crisis situation. The family may be told, you need to go for a guardianship. Mom no longer has the ability to sign the paperwork. Go for a guardianship. That guardianship also, it takes anywhere from 6 to 8 weeks. So if there's an emergency, it takes time.
Yeah. So it seems like the moral of the story is that really the advice for caregivers or spouses or anybody getting up in age is just to go to see an elder care attorney just to get your ducks in a row, because you're going to avoid so much heartache later on down the road. It's better just to have these things lined up for yourself and have the security that you have these things lined up for yourself.
Oh, I definitely agree.
Yeah.
Guardianship is, like I said, it's hard, and you're much better suited if you have made those decisions and you've created those documents that you are saying it's your control.
Right. So we only have a little bit of time left. If you had advice that you could talk to caregivers about, given your experience working with this world, what's the one piece of advice that you would want to give to caregivers out there when it comes to this topic?
I would say my one piece of advice would be to utilize the resources that are available to you, whether it's going to an elder law attorney, whether it's seeking caregiver volunteers. Research a little bit. And I'm going to tell you, I think the Caregiver Volunteers is an excellent resource. It gives you a lot of different avenues to think about. An elder law attorney can also, sometimes I say my work, I feel sometimes more like I'm a social worker than I am an attorney, because families will come and say, ask for advice or direction. So I think utilize the resources. Don't think that you're in this alone. There are so many resources available. You should take advantage of that.
Yeah, I think it's great advice. People feel so overwhelmed. It seems like it's just probably one more thing that people are telling them to do. But if you think of it, first of all, it's a gift that your parent is giving to you with this stuff. I think that the most painful thing is making a medical decision for a parent or anybody you love without knowing. I went through this personally, and I'll never get over it. I didn't know what to do, and I'll never get over that. So it's such a gift that you could give to somebody, and just doing it early before it gets into the crisis, I think that's just wonderful advice.
I agree with you.
That you're giving to people. So I really appreciate it. I think you give such a service to people. I can tell you probably really care about the families that you deal with, and you have their best interest at heart. So thank you so much for being a guest on our show today, and you gave out wonderful advice to people.
I've thoroughly enjoyed it. Thank you very much.
Thank you.